Hello, everyone, and welcome to today's webinar, Custom Curriculum Creation and Copyright, the Basics. On behalf of EdWeb, Xanadu, and Copyright Clearance Center, I'd like to welcome you to today's webinar. My name is Kelly Head, and I'll be your moderator for today's session. We'd like to encourage you to join our free online community for this EdWebinar. As a member, you'll get all of our resources, view and share the recording, take the CE quiz, download the slides and chat log. You can join discussions and then get invitations to the upcoming EdWebinars. You can join our community at edweb.net/pd. Our hosts for today are Chloe Duchesne and Chris Posa. Chloe is the Educational Services Coordinator at Copyright Clearance Center. Since joining CCC in 2019, she has developed an appreciation for the concerns and needs of content users worldwide. Her position in the Education Department allows her to stay up to date on the most current and interesting issues in the industry. Chloe hopes to improve copyright understanding and compliance for program participants and share with them best practices and real-world examples. Chris Posa is the K-12 Marketing Director with Xanadu. Most of his career, 20 years and counting, has been spent in the education industry, primarily with research resource providers Gale and ProQuest. Chris is passionate about education and believes that educators at all levels are some of the most underappreciated, underpaid people on the planet. And with that, I will turn it over to Chloe.
Awesome, thank you. All right, so I'm going to turn off my video while I dive in just because there's a lot to go over. So thanks again and welcome everyone to the session. As mentioned, my name's Chloe Duchesne and I'm the Educational Services Coordinator here at CCC. Now, some of you may be familiar with Copyright Clearance Center and others may not. We are a not-for-profit organization that was founded back in 1978 at the suggestion of Congress. We are the rights licensing experts. CCC collaborates with customers to advance how data is integrated, how it's shared, and how it's accessed. And while doing this, we really set the standard for effective copyright solutions that accelerate knowledge and power innovation. In short, we make it easy for people to get permission to reuse copyright-protected materials. So for today's agenda, I'm going to walk us through some U.S. copyright basics, followed by some limitations and exceptions to the law here in the U.S. So let's dive into U.S. copyright basics. The purpose of copyright comes to us from the U.S. Constitution, Article 1, Section 8. And I'll just take a moment to read this quote. To promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. So we're going to talk a little bit more about limited times and exclusive rights in a bit, but the purpose of the copyright law is really to motivate creators to produce content. Like most of us in our day-to-day lives, creators need to get paid for the work that they're doing. And I'm sure whether you're a faculty member or a student, you're able to relate to this. So let's take an author of a textbook, for instance. This content creator created a textbook that you're interested in using in your classroom. This textbook is the result of a lot of effort and professional skill over many, many years. So what do you think is going to happen if the content creator is not paid for the effort of their work? In my opinion, they'll probably stop creating content. And who could really blame them? If they're putting so much hard work, why continue to do it if it's not going to pay off in the end? So again, like us, the creators need to be paid for the work that they're doing. And if they stop creating, where does that leave us? Societies and users who need to gain access to the content. It would leave us with little content to choose from to better educate our students. So, what the law really tries to do is create a balance between the content creators on one side of the scale and society and users who need to reuse the content on the other side. Now, here in the US, you don't need to do anything formal in terms of copyright registration to own the right to a work you have created. So what that means is once a work is in a fixed and tangible form, it's automatically protected by copyright. And what I mean about a fixed and tangible form is that this could be something you have written down or typed it in an email. It could be a photograph, an audio file, or a video of any type. But as soon as it's in that fixed and tangible form, it's automatically protected by copyright. and this applies to both published and unpublished works. Once something is in that tangible, fixed form, the copyright holder is granted certain exclusive rights. And these exclusive rights can be found in Section 106 of the Copyright Act. You'll see here on the screen, the first of these exclusive rights is reproduction, which is simply recreating a copy of a work. This can be anything from photocopying something at your school to maybe printing an article that you read online in your own time. The next exclusive right is distributing copies. This can include handing out copies in your classroom, maybe emailing PDFs to your school district, or can even include posting content to your learning management system, something like a Google Classroom, Schoology, or a Moodle. So let's say you come across some content that you would like to share. Now, whether you decide to make 1 copy or 500 copies of that work, if you decide to distribute it to your school, this may be an infringement of the copyright holder's exclusive rights. And even though it's for an educational use, it doesn't necessarily mean that it will pass for fair use. And now, fair use is an exception to a copyright holder's exclusive rights that allows use of copyrighted works without permission in certain circumstances. So that's pretty complicated, and we're going to dive into that more later. So more on fair use to come. The third exclusive right is creating a derivative work, which could include translating content from one language into another. So for example, if you have the English version of an article for your classroom, but you need the Spanish version of that article as well, if you translate your English version, then you're making a derivative work. So other examples of a derivative work could include musical arrangements, art reproductions, or motion picture versions. Finally, we have public performance and public display. An example of public performance may be showing a video clip in your classroom, acting out a stage play or a scene from a movie, or singing or playing a song in your school's auditorium. Publicly displaying examples include posting a PDF, video, or image to a PowerPoint presentation, your internet sites, LMS sites, or even social media. Now, some people may be thinking that an LMS site is not open to the public, so why is that considered public display? Well, the exclusive right of displaying something publicly refers to people being able to access it. It doesn't mean the whole world has to be able to access it. So, displaying something on an intranet or internet site or LMS site allows some people to access the content, and that's what qualifies it to be publicly displayed. So if you don't have permission to post that content, you could be infringing on the copyright holder's exclusive rights. You might also be thinking to yourself that you protect the content you post with a password. But unfortunately, passwords are not a substitute for copyright permission. Permission still may be required to post that content, even if it's password protected. So those are the exclusive rights of copyright. Moving on, copyright duration. And this goes back to the limited times I referenced in the quote earlier. Copyright law has changed several times since it was first introduced, and in the Copyright Law of 1909, copyright registration was required. And the initial term of copyright was 28 years. When that time was up, it could be renewed for an additional 28 years for a total of 56 years of protection. But now, fast forward to the new law that was implemented back in 1976 and still remains in place today. It states that works created on or after January 1st, 1978 are protected from the moment of creation until 70 years after the author's death. So if you think about that, that's a long time. We have some pretty young content creators out there today. And I'm sure you all know that. You're in the K-12 space. You're seeing these young kids creating content for YouTube or all their social media channels daily. So 70 years after the author's death, copyright duration can last for a pretty significant amount of time. Now, in the case of works for hires, anonymous works, or works written under a pseudonym, the term of copyright is 95 years from publication or 120 years from creation, whichever is shorter. And the reason for that is that there's no debt date of death when it comes to content of that type. And now when we talk about content that's created under your employer, for instance, you're a teacher and you've created content for the school you work for or your school district. In most cases, the school is going to own the rights to that content that you created under your employment. It's not always the case. It will depend on how the contracts were written up between you and your employer, but that is typically the case, that works created under your employment belong to the employer. In some rare situations, it is possible that a teacher may have authorization from their employer to issue licenses on behalf of the school to others to use the work. Something like a teachers pay teachers opportunity online or something like that. But in most cases, the employer typically has plans to reuse that content on their own and would not authorize the teacher to license it out. So, in short, using a service like Teachers Pay Teachers or any type of online lesson plan sharing is okay as long as you're sure that you are only selling the content that is legally yours to sell. That's important to note. And when it comes to your students, they also have rights. They own the rights of the content that they create during the school year. So, for example, if there's going to be an art show that your school is putting on and you'd like to post some of that artwork online, you're going to need permission from the student to post their work because they own the rights to it. And with getting permission of any type, it's always best practice to get that permission in writing so you have a paper trail and something to refer back to in the future if needed. Okay, so let's now talk about some things that are protected by copyright and those things that are not protected. There are a variety of works that are protected, as you can see on the slide on the left side. Written works, as I've mentioned, of any kind, as soon as they're written down in a tangible form, are protected by copyright. And again, this can include something you jotted down on a scrap piece of paper, or maybe something you typed in an email, a wiki, a blog. All of that is protected. Images and graphs are also protected regardless of where they're found. And when we talk about images, I'm sure many of you use Google Images to search for images you'd like to include in your presentations. And there's something really important to note about this. When using sites like Google Images or anything online, really, it's important to know that Google Images is not the rights holder of all of these small thumbnail-sized images. They are simply the aggregator of where all these small images live. So if you went to Google Images and, say, searched for a lollipop, in seconds, you're going to have hundreds of pictures and little thumbnail-sized images available to you. They're right there in front of you. But that doesn't mean that you can take them freely and do what you want with them. Because, as I mentioned, Google Images is simply the aggregator, and it is not the rights holder to these images. So to use these images, you would need to go to the actual rights holder and request permission to reuse their image. So that's an important takeaway. Software is also protected by copyright, as well as sound recordings. And that doesn't only include songs, but also it could be a podcast or an audio file, any type of sound recording. Films are also protected. It could be a documentary, a Hollywood blockbuster, or even just a short, silly video you filmed on your phone. It's protected. And we certainly get a lot of questions about this, especially in the K-12 space, because a lot of times people like to use videos to enhance their lesson in a classroom. So they head to YouTube to see if they can find a relevant video on there. And once again, just like Google Images, YouTube is not the rights holder of all of the videos that its website holds. It's simply the aggregator of these videos, and they are not the rights holder. So to use a video in your classroom, you have to request permission to do so from the true rights holder. And to add a layer of complexity here, when it comes to videos, you also need to make sure you have permission for every element of the video. And what I mean by this is, say I take a video of my little brother dancing to Bruno Mars in my backyard. And later I decided to post it to YouTube because I thought it was hilarious. So that's for my personal use, and that's most likely going to be okay. But then what if we say a business or a daycare comes along and they also find my video funny and they'd like to use it to promote their business? Well, I can give them permission to use my video, and my parents could sign a model release for my younger brother, but I do not have the permission to sign away the rights to Bruno Mars music. I maybe wish I owned the rights to that music, but I definitely do not. So again, you really need to think about every component of a video and the permission required before you show a video in your classroom. And then lastly here, sculpture is also protected. And lastly, pantomime and dance. So that is the list of all that's protected by copyright. And remember, not until you put pen to paper or type it in an email is it protected. It must be in a fixed and tangible form. So if we look to the other side, we'll see the works that are not protected. This includes titles, names, and slogans. Those are usually not protected by copyright, but could certainly be protected by other IP laws like a patent or a trademark. Ideas, facts, and data are generally not protected. For example, the laws of physics or the periodic table of elements, not protected. But important to note too that when we talk about data, we're talking about raw data. So we often get questions that, can someone reuse a chart or graph without obtaining permission? But the answer is no. Charts and graphs are someone's interpretation of that raw data, and it likely has an original and creative element to how they put it together, and that's why you need permission to reuse it. If you have access to the raw data yourself, you are more than welcome to create your own chart or graph from that raw data and use how you would like. And then you would therefore be the copyright holder of that chart. And last on our list here is a simple list of ingredients or contents. So a to-do list or a very straightforward, no-nonsense, ingredients-only recipe would not be protected, but a cookbook and the way the author designs the cookbook, the way they format, the images, the stories they tell, that could be protected because they've put that cookbook together in a unique and creative way. So those are the breakdown of protected and not. All right, next we're going to talk about public domain. Public domain refers to a work that is no longer protected by copyright or it never was protected by copyright. As you can see from the slide here, there are three main categories of works that fall into the public domain. The first are works produced by the U.S. federal government when used in the U.S. Materials from the Department of Education or any sort of government agency you can take and use without permission. However, contracted works by the government may not be in the public domain and the contractor may own the rights. Also, please be aware that works from state, local, or foreign governments are usually not in the public domain and may require permission. Also, works where copyright lapsed because a work was published prior to 1925 are in the public domain. Works published between 1925 and 1963 that failed to register or renew copyright registration, or anything prior to 1989 and failed to include copyright notice, are all in the public domain. But I will say that the better known materials are most likely registered and renewed. So diving in a little deeper into public domain here, it's really important that when you're using public domain content, you need to be sure you're sticking to the public domain version of that content. So, for example, the Wizard of Oz books by Frank Baum are all in the public domain. If you want to make a derivative work of the Wizard of Oz, you can. But you can only use Frank Baum's version of the works. So that can get tricky. What do you immediately think of when someone says Wizard of Oz? Boom, for me, it's the movie. So when you immediately think of the movie, you need to know that the 1939 Wizard of Oz movie is not in the public domain. It is still protected by copyright and trademark law. When the movie was made, there were very distinct changes that were made to the content. So the slippers in the book were silver. But the movie came out during the advent of Technicolor, and they wanted something that was going to really pop off the screen. So in the movie, they changed the slippers from silver to ruby red. There's also a play out there called Wicked, based on a book written about the Wizard of Oz from the witch's perspective. And both the book and the play use silver slippers. They didn't take any of the details from the film, only the books, because the books are in the public domain. The play Wicked is also copyright protected. And lastly here, we have works that are gifted to the public domain. And that happens when an author just wants their work to be available and free for everyone to use and access. They can gift it to the public domain. So this is a really important concept. And before we move on, I just want to take a second to highlight one point here. So a work is not in the public domain simply because it is publicly available. So let's think about that. They're two very different things. As I mentioned, the public domain refers to works that are no longer protected by copyright or were never protected by copyright. While publicly available, thank you. While publicly available is anything that you or I could get our hands on. So anything in our subscriptions, our newspapers, or online. And today, honestly, that's pretty much everything. So everything is accessible with a click of a button, but just because it is publicly available does not mean it is in the public domain and free for you to use. So that is a key concept there. All right, now I'm going to talk a little bit about copyright registration and copyright notice. So here in the US, registration is not required for protection because protection is automatic once the work is in a tangible and fixed form. So this gets a little tricky because, however, registration is required in the US to file a lawsuit for copyright infringement. So even though registration is not required, it's highly recommended for a few reasons. It creates a searchable public record of the registration, and it also allows you to file suit in federal court regarding the US work if an infringement is taking place. On the right side of the slide here, we talk about copyright notice, the little C in the circle. And a work does not have to display this copyright symbol to be copyright protected. Copyright notice is not a requirement, but again, it's highly recommended as it alerts people that the work is protected by copyright. So it's important to remember that just because you don't necessarily see the copyright notice, the little C in the circle, it does not mean that the work is not protected by copyright. All right, so now we are at some real-world scenarios. Copyright infringement cases occur every day, and we might not always be hearing about them. Most are settled outside of court, but just because we're not hearing about them does not mean they are not happening. A recent case was Dynastudy versus Houston Independent School District. I won't go through the entire case, although it's very interesting. But in short, school teachers and administrators were making copies, distributing content, posting works online for anyone to download, and removing copyright information from Dynastudy's copyright protected content. Dynastudy even asked them to stop, but they continued. In the end, the courts found Houston Independent School District guilty of willful infringement, and Dynastudy was awarded a whopping $9.2 million in damages. So, pretty tense. Next, the Moppet case. Moppet Books were creating kinderguides for elementary schools using pieces of classic novels without permission. When a suit was filed, Moppet Books claimed fair use. So, the question, did the creation of versions of classic novels condensed and sanitized for children constitute fair use? Like I said, we'll get into fair use a little bit later. But the outcome of this case was that the court found no fair use. The judge rejected Moppet Books' claims that the works were protected by fair use. The publisher asked that the court to permanently prohibit Moppet Books from selling the books in question, as well as ordering the recall and destroying of all copies in the U.S. market. The suit, of course, also asked for damages and attorney fees. So even if they're not always front page news, these copyright cases happen every day across many industries. All right, so that was a brief and quick overview of some U.S. copyright law basics. And now I'm going to talk to you a little bit more about the limitations and exceptions to the U.S. copyright law that are in place today. The first is the first sale doctrine, which comes to us from Section 109 of the Copyright Act. And what it's basically saying is that physical ownership of a work is not the same as owning the copyright to that work. So for instance, all of us have books and movies that we've accumulated over the years and we've purchased, and now we own them. They're ours. And there's lots of stuff that we can do with those legally obtained copies. We can lend them to a friend, resell them, destroy it, or throw it away. However, we cannot use them to infringe on any of the copyright holder's exclusive rights. We can't reproduce them. We cannot distribute them. We cannot make a derivative work, and they cannot be publicly performed or displayed. The first sale doctrine, when it comes to digital works, gets a little tricky because the first sale doctrine can't really apply to digital works. Anytime you send someone something electronically, it automatically makes a copy on whatever server it touches. So if I buy a song on my tablet and I want my friend to listen to it, I would have to physically give them my tablet for them to be able to listen to the song. And I think we can all agree that that's just really not a realistic option. And this is a really great example of how copyright law is constantly chasing technology. The copyright laws are always trying to keep up with technology. It's just an age-old battle. All right, here we are. We have arrived at fair use. So let's get into it. We get a lot of questions about fair use, and that's because it's one of the most well-known exceptions to a copyright holder's exclusive rights. However, it's also one of very confusing topics. So, fair use does not mean that it is fair for you to use. Fair use is a defense to an infringement claim, and it is not a right to be non-compliant. To add to the confusion, the Copyright Act does not spell out any specific types of content reproduction that qualify as fair use. According to Congress, fair use cannot be clearly defined. If you copy and share a copyright-protected work and the copyright holder claims copyright infringement, you may assert a defense of fair use. But then it is on you to prove that your use met the standard for fair use. In these situations, a fair use analysis must be conducted on a case-by-case basis each and every time, and it is determined by the following 4 factors. These are the same 4 factors that are considered by a judge in a court of law, and each factor must be considered equally. No one factor can outweigh the other. We hear a lot that people look at this sort of like a math problem, like, oh, I got 3 to 1, so it's fair use, I can use it, or 2 to 2, it's a tie, I can't use it. But unfortunately, that's just really not how fair use factors work in a court of law. They are all considered equally. So the first factor here is the purpose and character of the use. Is the use giving the infringer a direct benefit, or has the use transformed the original work in any way? It's important to keep in mind that the business benefit gained is not all about financial gain or profit. Even if you're a not-for-profit, no matter the organization type really, if you're gaining a business benefit from the use of the content, it's less likely to be seen as fair use. The other part of this factor is how transformative it is. The less transformative, meaning the more like the original work it is, the less likely it is to be considered fair use. The second factor here is the nature of the copyrighted work. Is it a factual work, such as an autobiography, or is it a creative work, more like a work of fiction? Generally, creative works are granted higher levels of protection, and this factor can weigh heavily when a creative work has been infringed. But this can be a gray fair use factor. It's hard to know. There are factual works out there that may still be protected by copyright. Even factual textbooks can be considered creative works because the writer is interpreting facts and laying them out in a creative way. The third factor is the amount and substantiality of the portion used. Here at CCC, we get this question all the time. How much can I take? Can I take a sentence? Can I take 10%? What about one page from a 100-page book? But the reality is there's no set page counts or percentages. Even a small portion may be too much if what's taken is considered to be the heart of the work. And I think it's probably safe to say that you and the rights holder will likely disagree on what is the appropriate amount to take. And the last factor is the effect of the use on the market or the potential market. So did the infringement result in an economic loss that the copyright holder would otherwise have been entitled to receive? So those are the 4 fair use factors. And again, they're all weighed equally each and every time. Just because one case was ruled fair use doesn't mean a similar case will be ruled the same. All right. Now, copyright law provides educators with a separate set of rights in addition to fair use, and that is to display, show, and perform, show or play, others' works in the classroom. These rights are in Section 110 of the Copyright Act, and they apply to nonprofit educational schools. However, please note that this is a small exception to the rule, and it's important to understand that this is for spontaneous, in-the-moment teaching in a face-to-face classroom environment. For instance, if a teacher comes across an article that applies to what they're teaching that day and they would like to make copies for the classroom to enhance discussion, excuse me, that's fine. And they could make copies to enhance the discussion that day, that one time. It's not something you can do over and over again, but once. It needs to be spontaneous and in the moment. So any content that's scheduled in the course or contained in the syllabus, listed in the curriculum, or taught throughout the year would not be considered part of the performance and display limitation and exception. Now, the second bullet, we get into Section 110.2, which is the TEACH Act, Technology, Education, and Copyright Harmonization Act. And this act aligns with Section 110.1, which is the face-to-face teaching exemptions with distance education needs. Again, the TEACH Act applies to accredited nonprofit educational institutions, and this is for the in-the-moment, spontaneous teaching. Now, I'm sure most of you are familiar with open educational resources, or OERs, and they're certainly a growing trend. Many schools wish to use OERs to reduce costs, enable customized learning through remixing and contextualizing of OER content and materials under an open license. But remember, just because something is open does not always mean it's free and that you can take it and reuse it without permission. OERs are copyrighted content used under an open license, such as a Creative Commons Attributions license. OERs may contain third-party content under copyright that may be beneficial to your curriculum. However, the third-party content used under a fair use claim may or may not apply to your specific situation. Another important note to add here is that even if one school in the district or one teacher in your school gets permission to reuse certain content, that permission does not transfer to other teachers in your school or other schools in your school district. Each and every other use of that content request must be approved in addition to that first request. We typically get a lot of questions about the classroom copying guidelines, which were created by a group of copyright holders and representatives of academia who were trying to fix rules around fair use in the classroom. They were always only intended to be guidelines, and the key to interpreting them is really this. 1, brevity. You can't keep too much. 2, spontaneity. It can't be planned. And 3, the cumulative effect. If you're sharing the same thing year after year after year, you really should be getting some permission. Great. And these next 2 slides are just some common copyright myths versus facts. I'll just read a couple of them for you. As I mentioned earlier, passwords are not a substitute for permission. Attribution is also not a substitution for permission. Many people think giving attribution to an author will relieve them from a copyright infringement claim, and that's not true. Attribution is nice to do for the author, but the truth is that the author may no longer even be the copyright holder, and they may have turned over their rights to the publisher to be published. So it's important to make sure you contact the copyright holder to request permission to reuse content. And here are just a few more myths versus facts that I'll leave up for you to read. And that is the end of my slides. So I know I've given you a lot of information in a short amount of time. But if you take one thing away from this talk today, I hope that it is, when in doubt, get permission. It's that simple. It's always great to have a backup. It may not even cost you money, but you still may need permission to use it. So keep a record of your requests for permission, write everything down, and just be sure you have documents to look back on for the future if needed. So with that, I think we're going to open it up for questions now.
Yes, thank you, Chloe, for that great information. We have a lot of questions to get to. So
Awesome.
The first one that seems to be asked quite a bit is, how does a person go about requesting the permission for the copyright?
That's a great question. And yeah, that is a very common question. It really takes a little bit of detective work. If you search for that image on Google Images, you find the one that you love and you really want to use, you got to click through and find the site where it's truly originated and where Google is really pulling it from. And then you kind of need to investigate even more and see if you can email them through a contact us type email, or maybe they have a link for it. But it's really about getting in contact with the true owner of it. And it's really just about effort, honestly.
Okay. The next question is, how does creating a derivative work with the original copyright?
How does creating a derivative work against the original copyright?
I think that's the gist of the question, yes.
Yes, totally. And if I misinterpreted, please resubmit your question. But so creating a derivative work is using someone else's maybe kind of core idea and then expanding on it and building out other things, like the Wizard of Oz did with Frank Baum's books. He created a derivative work by changing certain elements within the books and then made that his own work. So I hope that answers your question. But if you want to clarify or if I misinterpreted, please chat that in.
Okay. Someone would like you to define exclusive rights.
Sure. So in another webinar we define exclusive rights sort of like a bundle of sticks. And it's meant to be in a way that you can never really know how many are in there if you're looking at it from the top. And that's the same with exclusive rights. You can drill so far down into exclusive rights for particular situations and grant people permission for such particular instances that really exclusive rights have almost an endless options that you could do. I'll throw out an example here, maybe that will help. Let's say Chris owns a movie theater and he wants to play a movie that I've created. And I tell Chris that he's allowed to play my movie on Tuesdays in months that end in R. And then someone else comes along and they want to play my movie too. And I say that they're allowed to play it on Thursdays in months that end in R. Those are both exclusive rights that are mine to give away. So I hope that helps. And that's an example that really helps me understand it. And it's just that you have all these rights. And even though we went over a couple big buckets, you can always keep kind of drilling down in there, finding more exclusive rights.
Okay. Here's another question. I was told by a teacher that he could not send me a photo of a class worksheet developed by the textbook publisher and copied, distributed, used for classroom instruction. He had photocopied from a master provided by the publisher under permission for classroom use. Was the teacher correct?
Yes, he was correct. And good for him, because it's hard to say no to colleagues when it seems like just a copy, But he was correct. And if they were only licensed that one master copy, and that's what he had permission to make a photocopy from, then he was correct that it would have been a copyright infringement for him to send you a picture of that work.
Okay.
Or that worksheet.
Another question, do we need to register the material with the Copyright Office?
That is a great question. And while it is almost personal choice, because as I've said, fixed and tangible, if your work is in a fixed and tangible form, you automatically have copyright protection. But if, if your idea is so awesome and someone steals it, then you don't have it registered. You can't sue for those infringements. So that's why it's so highly recommended to register your work, because it creates that searchable record of registration and allows you to file suit if it is taking place. And you can register copyright at I believe it's copyright.gov. I think that is where you go to register your copyrights.
Okay. Does a teacher own the rights to content that she created if the content was created outside of the school day?
Ooh, that is a good question. I think a lot of answers to copyright questions is that it depends. So I'm going to have to say for that one that it does depend. If it was content that's related to your main employment, I would imagine it would still belong to the employer, even if it was created outside of like school working hours, if it was related to your job. So I think that if you're a teacher and maybe you were like making something else that didn't really have to do with teaching, like maybe a hobby or something like that, I think that would fall outside of the employer's sort of umbrella if it was out of your job requirements and kind of responsibilities.
Okay.
I hope that makes sense.
How realistic is it to get consent on content sharing from someone like Banksy or Marshmallow or anonymous rights holder as an educator?
That's a really great question. And that sort of goes back to just documenting your process for requesting permission. If you really need to use that Banksy image, which I mean, it's so cool, you probably got to use it. And he doesn't really seem like the guy that's probably going to get back to you. But you got to go online and look. Maybe he has a manager or there's some type of email account that you can reach out to. So you email that account, you ask for permission, and then you save that email in your files and have it on record for you to refer back to if you end up using that Banksy image, and then his manager or someone comes back to you, or the copyright holder of his images comes back to you and says, you can't do that. That's ours. You have that saved email to be like, well, I did try to ask. And then it could potentially be a fair use situation. And it would really depend on the further legal actions of Banksy or said non-responsive party. But it's just always good to try. I don't mean to ramble. It's just hard to explain. And it's just always good to try and document your questions, document the responses from people if you get permission, or if you don't get permission, it's just good to save them and have them for your records.
Okay. If I used someone's YouTube video and gave credit to that person, is that legal?
That's a layered question, and I appreciate that, because YouTube is, it's a copyright minefield. Honestly, it's very hard to regulate what's going on YouTube. So if you used a friend's video, and I'm sorry, did it say friend? Did the question say friend? Or
just says someone's YouTube video.
So to use another person's YouTube video, you need to get in touch with them and try to either, whether it's through their channel in the contact us tab or something like that, it's really best to try and get in touch with them and ask for permission to hopefully avoid an infringement. Paying attribution, as I went over briefly at the end, it's not a substitution for permission. So even though it's nice, the person in the video, say it might not be their video, they could just be a model or an actor, and a different company or a different person actually owns the copyright. So it's really important to try and get in touch with that actual copyright, the rights holder, if you're going to use it. So paying attribution is nice, and the people in the video or whoever created it might appreciate it, but it does not relieve you from a potential copyright infringement claim.
Okay, thank you. Can you address PDFs of novels that teachers find online and put in their LMS for students to use?
I can try. I have never received this question before. So anything you find online, if it's not expressly listed as it's in the public domain, it likely has an owner who has its rights and needs to, be paid for the use of their material. So I can't say for certain if these novel PDFs were in the public domain. I would doubt it. I think that's a rare situation. So to take something online that you haven't subscribed to or paid for in any way and put it into your LMS is likely a copyright infringement.
Okay. Here's another question. What if the author is not from the USA? Are other countries' copyright laws similar to ours?
That's a wonderful question. And I will say that there is no international copyright law that covers the world. So every country, the US, other Canada, they all have their own copyright laws. And so if you're looking to get permission from an author from another country, you really need to do some research and then also speak with them and see if they have any limitations or restrictions or stuff like that in their country that you may not be aware of as a US citizen.
Okay, another question. Is verbal permission okay?
Ooh. Oh, now that's a good one. I'm going to definitely have to take that back to our in-house lawyer and see what he says about that. I think it would probably, I don't know, and I don't want to say the wrong thing. Hard to have a verbal permission in reference. So I don't know if you could record them saying it or if it's that casual and passing that they say yes, they probably wouldn't sue you, is what I'm saying. But when we get the reports from this, I'm happy to follow up with our lawyer and I can get back to whoever asked that because I'm just not positive about verbal agreements. That's a very good question.
Okay, another one. If you find an image but change it to make it your own, are you safe?
That's a tricky one. Most likely you would still need permission from the copyright holder if you're using that image that you've changed to better your business. So kind of going back to those fair use factors. And if you're, say, maybe you have a student who takes like an album cover and they customize it and they put their friends and their faces on the people on the cover. And then they submit that to you as like their art project. That's likely going to be fair use because it's personal and like it's just for that student. But if that student then tried to sell their painting with the same album sort of artwork and photographs, but the different faces, that would be probably a infringement claim, and you'd have to do a fair use analysis on that one. But like I said, for personal use and stuff, that would probably be okay.
Okay. Are copyright laws only enforceable if I want to monetize any lesson or materials that I create?
Copyright laws only. I'm sorry, could you read that one more time?
Sure. Are copyright laws only enforceable if I want to monetize any lesson or materials that I create?
I'm gonna have to get back to that one too. I'm sorry, I'm
Okay.
not sure, and I don't want to be wrong.
No problem. If something is produced by the federal government, does it need to have express copyright permission / public domain in order to be used?
Ooh, great question. So yeah, going back to that public domain slide, if the work was produced by the federal government or the Department of Education, anything at that federal level, you are free to use it without permission. But state governments, local governments, or foreign governments are likely not going to be in the public domain and you would need permission. So works coming from a federal level, free to use it in the public domain, but works from other types of government most likely require permission.
Okay. How would I know if something that has passed the date of protection has been re-registered for copyright?
Oh, very cool question. I've never even thought about that. Is a so when you register your copyrighted work on the copyright.gov, it creates the searchable record. So I would believe you could go there and probably search for the work or the type of thing you're looking for, and you can probably see the dates there of its copyright protection.
Okay. All right, we're going to wrap up the questions for now and move on to Chris's portion of the webinar, but we can post answers in the community discussion forum at a later date and also the ones that you needed to go back and clarify. So at this point, I'm going to turn it over to Chris Posa, who will talk about Xanadu Publishing.
Okay, hi everybody, and thank you, Chloe. So as Kelly said, I'll finish up by telling a little bit about Xanadu and really where we fit with what you've heard Chloe talk about copyright, and then as it relates to curriculum development. So with 20 years of custom publishing experience, supporting both higher ed and K-12 schools, we've been helping districts improve relevancy, equity, and access through customized instructional materials. And so rather than asking students to adapt to a standard off-the-shelf resource, our custom solutions help you make education personalized and affordable by giving you control to create unique materials based on your specific students' needs. And so we like to say, essentially here, we empower curriculum creators to take back control of the content, quality, and cost of your instructional materials. And so we've heard from our partners that the traditional textbook model is not meeting the needs of the classroom today. I'm not saying anything you guys don't already know there, quite frankly, but one textbook simply does not address the needs of every student across a district or state. And with adoption cycles being 4, 5, 6 years, those textbooks often become outdated. And of course, the costs are at an all-time high while your budgets are shrinking, which makes your content decisions extremely tough. There's also a growing emphasis and need on localization. Think back to just this past February. For example, Oklahoma announced that the state will incorporate the 1921 Tulsa Race Massacre into the statewide school curriculum. A lot more examples just like that have been sort of popping up for quite some time now around the country, and I think that's going to be the case going forward, certainly. Districts need flexibility to alter instructional content based on current events, unexpected standards changes, or new mandates. The recent events of this spring and summer are probably perfect examples. So, I imagine many of you are busy determining how to integrate the topics of COVID and social justice into your curriculum plans, no doubt. And that's where we come in. So Xanadu has the ability to help address those previous problems I just mentioned by empowering your districts to utilize our K-12 custom book solution. And in a nutshell, your team of content experts identifies the perfect materials from any source, and we manage all of the copyright review, licensing, design, formatting, layout, as well as production and distribution of your print or your digital custom book. A couple examples of how we partner with districts. So in English language arts, for example, we find that districts' materials don't always include complex informational or background texts. And some of our partners have identified those perfect text sets, including those needing copyright. And so Xanadu managed the copyright permissions and created a distribution method for those districts and schools to access specifically printed readers. Another example, districts and state level partners who are creating curriculum utilizing, as you heard earlier, open educational resources often benefit from the inclusion of those high quality text excerpts or other copyrighted items. And so we solve those licensing and production challenges associated with those, call them custom initiatives. And so how does it work? So as I mentioned, you choose the content. Xanadu is publisher neutral. The contents of your workbook or your readers can be, again, text excerpts, a specific chapter from a textbook, primary source documents or articles from newspapers, magazines, journals. Your goal is, right, to identify the perfect content for your students, and then we manage that permissions or those permissions, indemnifying your district of potential copyright infringement. And then we also do the heavy lifting. So we have an expert team of book editors and designers that'll work with you to tailor the content layout and design to ensure your curriculum is uniquely you in every way. So teachers no longer have to spend hours, for example, trying to format different content types into a cohesive printout or standing at copy machines, printing hundreds, or the reality is probably more like thousands of pages. So our flexible delivery capabilities enable you to distribute really at scale, at any scale. So whether it's your individual schools, district-wide, throughout the state, and even nationally, taking the challenges of implementing, taking the challenges out of implementing a custom solution. This is kind of interesting data here. So what are the most common or popular sources or types of information for which we are asked to seek permission? It's a little bit difficult to see there. I think maybe on your slide, so I'll walk you through it. But what we did was we recently took a sample of requests and broke it down into a few categories. You can see some of the more popular ones here, with books at about 20%, journals and magazines at about roughly 23%, and other web sources. So anything else not listed here is grouped into that 28% part of your pie chart. These are entirely in the ELA and social studies categories, plus some items from a Spanish curriculum that we're working on as well. Here we're at about 85% ELA. I think it's skewed just a little bit by two really large projects that we just completed. And almost everything we clear is online. So it's pretty unusual to be given a source that doesn't point to a URL, even the book sources. So our customers find the text somewhere online if they can, and that's how they are locating the material for the most part. Here you see the things we need to know about the project. And so this kind of came up, I think, in the questions a little bit earlier. Most importantly, the quantity, distribution, and the format questions are vital, and we actually cannot start a permissions project without them. So licenses are strictly for those terms. And if you decide after the fact to change one of those, and it does happen from time to time, say you want more copies, or you decide to add a digital component to what was a print-only product, then the licenses need to be re-requested and redone. The pricing changes, and it might add a little bit of time, to the specific project as well. And so we work with our customers to really make sure that those important things are decided upon and outlined properly at the outset of a project to make sure that everything is delivered on time and exactly as expected by our customers and ultimately then users, your kiddos. And just a couple of things here to clean up then. So in terms of some examples of some of our work, so we support the Open K-12 ELA curriculum named Guidebooks. And Guidebooks was actually created by content experts identified by the Louisiana Department of Education. And the curriculum is currently open, and it's available for Louisiana districts to mix and match units as they see fit. And we provide the districts with an easy pathway to access the copyrighted short text, printed consumable student workbooks and teacher manuals, and we're working with on some other things, especially as you think about all of the massive shift into online learning. And so they're doing some different things there, getting ready for the school year, and we're working with them on those. And then lastly, of course, for COVID, during this incredibly challenging time, so some of our partners have identified that they just needed printed materials to help improve their remote learning experience. The ask of going online virtually overnight was not a reasonable one. And so you can see here how we've recently worked with DPS and Baltimore City Schools to help get printed materials into their students' hands quickly. And again, at scale, that's really important. You can see the massive amounts or the massive quantities that were needed, and then the distribution over weeks and weeks of time. We were able to work with them to meet those. And then, of course, get them in the kiddos' hands via whatever method they needed our help with. And sometimes it was just distributing those materials directly to meal distribution locations. A lot of districts have been doing that, as you know. And in some cases, we actually had the materials delivered right to the students' doorsteps. Texas Education Agency comes to mind there as well. You can visit our website. It's xanadu.com, Xanadu with an X. And you can see that we've got some additional resources that I think would be useful for you. Some tips and tricks on printing and distribution, whether you work with us or not, that will help you really make sure you stay within budget and can get things done in a timely manner. We've got some copyright information, tips and tricks posted on our website as well. And then somebody had asked earlier about open source or open educational resources. We've got a page there with lots and lots of those available to you, keeping in mind A number of them were made available way back in the spring when the outbreak hit. Publishers may not be offering those materials as openly and freely, really important to our discussion here, as they did. But there are certainly references to plenty of resources for you across all of the subject areas.
Thank you, Chris. Just going to see if we have any additional questions. Okay, here's a question for Chris. Are the custom books that Xanadu produces print books only, or are they also ebooks?
We also have a digital platform that our materials can be distributed through as well. Most of our work is through printed materials, but again, we've got an online ebook platform that can be leveraged for distance learning. Obviously, incredibly important these days.
Okay. Someone is asking, if someone is creating a textbook while working for a school, how is it possible that they can get it copyrighted under their name? I think they're talking about the guidebooks, how that's arranged.
I think that was more of a Chloe.
Yeah.
That sounded like it went back to, as a full-time, salaried employee, that discussion you were having earlier there.
Oh, sorry.
Yes, I think so. Oh,
That's
no,
okay.
no. So I think that, it really would depend on how your contracts were written with your employer. If you happen to be working at maybe an elementary school and you were publishing like a higher ed textbook, maybe, but typically work created in the same industry as, your employer and your industry is going to be, the rights are going to belong to your employer. So it'd have to be specifically worked out with your employer if you were, doing a textbook for your own benefit on the side or something.
Okay, another question for Chris. Can Xanadu arrange translation of foreign language work excerpts?
We can, yes. Yep, we've actually done that in the past. Yep.
Cool.
Okay, and does Xanadu work with universities and higher education institution as well?
Yeah, absolutely we do. It's funny you should ask that. I mentioned at the outset of this, been in the business for about 20 years now. Boy, if anybody can think back to their college days and they went to the bookstore at the start of a semester, you most likely were assigned a course pack by your professor or a faculty member. And it's highly likely that Xanadu had a hand in the production and the distribution of that course pack that you use. So yes, absolutely.
Cool.
Okay, great. Well, thank you so much, Chloe and Chris. We are going to wrap up now and conclude today's session. I just want to remind everyone they can join the free online community for this Ed webinar. As a member, you'll receive all the resources available to view and share the recording, take the CE quiz, download the slides and chat log, join discussions, get invitations for the upcoming Ed webinars at edweb.net/pd. Thank you so much for joining us today. We appreciate it, and I will be following up with an email the next day or two, and I hope everyone enjoys the rest of their day.
Yes, thank you. Thanks for the lively chat.
Thank you, everybody.
Great audience. Thank you, Chris and Ed Webb and Kelly. And yes, I'll get back to those other questions as well.